waive such. And it's difficult to waive such allegations. And, you know, a number of times, a few cases, corruption, judges have been indicted of corruption in, you know, a pocket number of cases here and there. So we cannot completely deny. And sometimes corruption, not just with the judges or the magistrate, even the people prosecuting, people that are even working in the system, you know, receiving bribes or, you know, setting, compromising in one way or the other to favor certain parties. And it can deny somebody access to justice, because somebody that has a good case will end up losing that case because for one reason or the other, another person found favor and was favored above him. And the person got judgment, even though he didn't merit the judgment. That's justice denied. You know, access to justice is not just about taking your matter to court. It's about getting your case, you know, being prosecuted based on merits, and such that even whether you lose the case or you win the case, you are sure that the matter was treated on merit, and you go home, even if you lose, satisfied that, yes, by the evidence before the judge, you didn't merit the case, and as such, you don't seem to blame the system, even though everybody that goes to court wants to win. But there are some cases that right from the time you are going to court, you know precisely that you don't really even have a good case, but you want to just try out your luck and see if it will work. So in such instances where a matter is decided based on merit, and you will clearly see the merit and the transparency involved, even when you lose the case, you can say, yes, you got justice, even though you lost, but it was justice done. Now, we have other barriers like language barrier. But, you know, under the constitutional right to fair hearing, we notice that where the language of the court in Nigeria is English, but where somebody who is a litigant or somebody is a witness I cannot understand English very well, the mandate is upon the court to assign an interpreter to such a person so that he can do his case without being hindered on account of language barrier. But then in some instances, despite the interpreters, there are some people that they have low level of literacy, such that they are not so knowledgeable about what the law itself requires, and it can deny them access to justice. And some who even claim to have understood the language of the courts may not understand the depth, may not understand the depth or the technical meanings that accompany the legal language, such that sometimes they end up giving responses to certain issues they are not so knowledgeable about. Now, on the issue of literacy, let me also stress the fact that we need enlightenment on the issue of access to justice. The need for people to be enlightened and to be aware that they are entitled to justice, they are entitled to rights, and they can approach certain quarters when those rights are violated. There is need for such enlightenment by our traditional institutions, even by our religious bodies. People need to be enlightened. Our educational curriculums needs to be to incorporate legal enlightenment or basic legal education at all levels, right from primary education, secondary education. Things like fundamental human rights should be taught, and people should be encouraged to read the Constitution so that they have basic knowledge of what is required of them or what is required of another person as far as their own rights are concerned. So it's also an impediment, because where you do not know what your rights are, it's possible to look out for it when it's not there. You know, so it's important. It becomes a barrier to access to justice. you do not know that when your rights are violated, you can seek for enforcement of your fundamental human right. So they can be violated, but you do not even know that they are violated. So at the end, you have the court that could have awarded cost in your favor in enforcing your fundamental human right, but you were not aware. So as such, we can say that justice is also denied on account of your illiteracy and lack of knowledge, which is nobody's fault, but at the same time, avenues should be created where people can be enlightened on the procedures, the basic rights, the procedures, where to go, what to do, and what not to do. So poverty and inequality, yes. Many people, the poverty becomes an issue of the mind itself. Like I said, some will not even make efforts to even say, okay, at least let me talk to my neighbor who is a lawyer, or let me talk with a family member who is a lawyer. At least the person can basically tell you what to do. I think in the course of this class, some of you are now aware that there's an agency of the government called the Legal Counsel, Legal Aid Council, where lawyers are paid by government to prosecute cases free for people who are standing trial for capital criminal offenses. And the Human Rights Commission is also made of lawyers who can take up cases of violations of fundamental human rights for citizens who are indigent and cannot afford to pay. Then there are legal activists that do cases on pro bono basis. That is, they do it free for people who are indigent, and such can be gotten. There are non-governmental organizations that also volunteer. Some are made up of lawyers and development workers together, and they can volunteer to take up matters for people who are indigent, for people who are helpless, and for people who do not know what to do. But sometimes we have them all around us without even knowing that we can access such people and get justice where we cannot afford to pay all by ourselves. Now, one of the systemic barriers to access to justice in Nigeria is lack of judicial independence, where judiciary is so interfered with, where the executive is threatening the judges that if you do not do our bidding, you lose your appointment, or they find all ways of indicting them, frustrating them, making them lose their clarity of judgments. Where the judiciary is not independent, the whole system of justice is, can collapse. For example, independence of judiciary simply means no interference by the executive arm, no interference by the judiciary arm, no interference even by the high and the strong in the society. Cases like people, traditional rulers or political leaders turning around to go and talk with judges who are prosecuting cases of their interests. Either their family members or their friends are involved, and they are beginning to drag these judges or people they bench into influencing their decisions. Where such happens, it becomes an interference. And where that is the case, the judiciary is no longer safe. Sometimes we hear allegations of where judges that insist on the right thing are being threatened, their lives are threatened. We had an incident in Nigeria here where one of the INEC state official commissioner was burnt during election. That's interference. And sometimes these judges are threatened in one way or the other, directly or indirectly. Sometimes they receive threat letters, sometimes both on themselves and their families. And they know exactly the cases they are handling that is bringing about that. Election tribunals where judges go, they are influenced with money, they are influenced by the environment, because everybody in the environment is either for one particular political party. And it's so obvious, it's so glaring that the whole environment is toxic, the whole environment is filled with intimidation, it's frightening. So the judge is trying to at least be alive and is influenced directly or indirectly by what is happening, and he cannot be courageous enough to take a bold decision You know, sometimes even the security agents are compromised, and the judge is not sure if he's actually even protected, because instances where the law enforcement agents claim that they did not receive directive from above to take certain actions, then this person's life is in danger, and he needs his life and his family needs him. So at such instances, people can easily compromise. Some may do that, not that they plan it, but the circumstances around warrant and compel them to do so. So that is a systematic barrier. Now, the inadequate infrastructure is also a systemic barrier, where you see that the court system, some of the courts, the infrastructure is so dilapidated, is so limited, especially in the face of the technology. Many judges are not trained in ICT. At this moment, it is expected that judgments should be recorded automatically, or hearings should be recorded automatically. Yet in many of our courts, we still see the judges that age writing, recording their proceedings by their hand, you know, which by human composition or by human make, they can forget certain things. At this level of ICT, proceedings are supposed to be recorded automatically, where these judges sit back and as the litigants are testifying or are standing in cross-examination, this proceeding should be recorded automatically with the help of ICT, so that the judges can sit back, follow the proceedings recorded, and take their decision without having to go through the stress of writing and writing and writing. So the infrastructure, sometimes the court system are also not convenient at all. They are not conducive. You see the judges sweating. You see some of them having to adjourn sittings on account of heat, or some courts, you literally even see where the courts are leaking and it's raining there. And sometimes in some jurisdiction, even security-wise, there are some courts that for sometimes the judges cannot sit on account of insecurity. So the entire jurisdiction suffered delay of cases. Now, this time of insurgency in Nigeria, there are certain courts that cannot sit because the place is not safe, even for the indigenes. It will not be safe for them. So all the cases that are waiting in their courts, we have to wait for as long as they cannot sit. Those cases are waiting. And sometimes justice delayed is justice denied. Certain things are overtaken by events. Certain things become useless with time when they are overly prolonged. And even some of the judgments are gotten when the people that filed the cases have died, or the events, is no longer useful. So all these things, constitute barriers to access to justice in Nigeria. In as much as this justice is supposed to be so available and within locations such that everybody, because if you look at the siting of courts in Nigeria, you will discover that courts are supposed to be sited in every locality. Every local government should have magistrate courts, should have area courts. Not just local governments, all the local governments, all the districts, in fact, to a level, all the clans, should have area courts, should have magistrate courts, and all the major senatorial zones, or even major towns in every state, they're supposed to have at least 1 or 2 high courts. So that all the cases that are coming from the villages, from the localities, from the magistrate court, the lower court, the area courts, are supposed to come to high court for appeal. And all the capital offenses that this lower court don't have jurisdiction are supposed to come to the high court, and these high courts are situated. And I think the example of Benue State, we have courts everywhere. Now, we have these courts everywhere, but the question is that some of the courts that are situated in very volatile security areas, how many judges will risk their lives to go there? Now, in the worst case scenario, this court sometimes are relocated to places where it's a little bit safe. And that now puts the litigants in a difficult situation because some of them cannot travel all the way. Some will have to both travel and transport their witnesses to come all the way. And once they cannot afford, it's not possible to prosecute such cases. Even when they are prosecuting them, it's not possible to do it well because in the absence of their witnesses, their cases can just be jeopardized. So in as much as these courts are available, accessibility becomes a problem, is hindered on account of a systemic failure, on account of insecurity, on account of certain environmental factors. So now we are moving into a very key component of access to justice, which involves you and me. I mentioned that yesterday, particularly that is why I didn't assign this for anybody to present on. Now, where the can I say the structure or the statutory court system is not so available on account of the barriers we have mentioned, what's the option that can grant justice to at least to an extent? That now takes us to the alternative dispute resolution, the ADR, which now you can also be a key stakeholder. You can partake, you can be a facilitator, you can be an intervener, you can be helped and you can help another person without necessarily going to court. Now, this alternative dispute resolution, ADR, there are mechanisms that are used to resolve dispute outside traditional courts. Available tools that can be used when you don't necessarily need to go to court, but also to intervene in one way or the other. Now, what are these mechanisms? The number one we have on the list is mediation. A mediation process is a situation where a neutral third party facilitates in a conversation between parties to help them reach a mutual acceptable agreement. What do I mean by that? In a class, let's put a class scenario. There's a dispute that has occurred in the class, our class now. Now, in a bid not to necessarily go to court, let's say that Joseph becomes a mediator between Precious and Grace. Grace has an issue with Precious. They are arguing over an issue and everybody feels I am right, Grace is right, Precious is right. And they don't seem to be coming to a point where they can resolve the issue by themselves. So the natural thing is for them to go to court. One person will sue that this is my right. This person will insist it is also my right. Now, in such a circumstance, where they cannot have access to court on account of one barrier or the other, Joseph becomes the mediator. What is his own role? He comes in, he sits the two parties down. Now, he helps he helps Grace to understand that, yes, this is your right. He helps Precious to understand that, yes, this is your right. Okay. Now, he helps them to understand that it is my right, it is your right, but we must have to come to a point where we agree. So he both helps them to see the extent of their rights. This is where your own right starts. This is where it stops. This is where your own starts. This is where it stops. And he must be very neutral. He must be very, very impartial in his disposition, in his mien, in his approach, in his tone. He must not be seen to be taking side with one person. Because the moment he does that, he's already violating the rules of mediation. He must be very neutral in his conversation. He must ensure that he wins the confidence of Precious and Grace. And to a point that they can trust him. They can both become relaxed. From his tone, from his approach, from his use of words, he now possesses the capacity of an arbiter. An arbiter can be a judge. An arbiter can be a non-judge. Now we are talking about a non-judge arbiter. because he's not affected. He's not involved in this dispute at all. An arbiter must be somebody who does not have an interest at all any of in the disputes. He's not affected, so he's emotionally not attached to any of the parties. He's a complete neutral person in the matter. So when he comes, he looks at these cases from the lenses of neutrality, and he's not attached in any way. He helps both of them to trust him. He makes them to trust him. He helps them to see that, oh, this is the extent you have gone, this is the extent you have gone, but this is the extent you should also stop. You know, so when that happens, he helps to convince them that there must be a solution to this issue. And he prepares their minds that in mediation, there must be shifting of grounds. You must not insist on your position. So he seeks to intervene to help them to see where they can voluntarily shift ground and come to a point where they will then both agree that, okay, let's look at the scenario of maybe somebody, what's the right scenario? I'm thinking. Yes, so let me think that out later. But some of the key ingredients in mediation is that both parties must be willing to let go of something for the sake of, you know, solving a problem. Because you look at it that, okay, if I lose this to this extent, if I lose to this extent, it will help me in resolving the problem. So if the problem is resolved, I'm at peace. You know, what I've lost is not so instrumental to my existence and I can afford to let go. Whereas if you insist, one person, if he goes to court, is capable of losing everything, but in the circumstance, you both sit down and the third party helps you to reach an amicable solution. One of the advantages of mediation or ADR is that it helps both parties to be at peace and to be psychologically, to psychologically accept both defeat, or can I say defeat? Because in mediation we say it's a win-win situation. I'm ready to let go, so I don't see myself as a defeated party because I willingly allowed it to happen. So I go home, even though if I don't have 100% what I came to look for, you know, and where I don't have all that it takes, but to a large extent, I'm sure that I'm not aggrieved compared to litigation where you go to court. Is the pronouncement. Please, who is the person that Jeffet? Can you off your mic because you are disturbing the class? So in mediation, the parties are psychologically relieved. They are also convinced that they were part of the process, and they are not going home grieved that it's the third party that imposed his decision on me. So it's an option that can be taken by a responsible member of the society. You know, at all points, mediation take place. Mediation take place in homes. Somebody can even, you can intervene where maybe parents are fighting with their children. It's mediation. You can mediate. Instead of watching them fight and, you know, injuring one another, you can mediate. You can mediate as a responsible member of the society. You can even mediate in landed disputes where they are not so violent. Where communities are disputing, it has not gotten to a level where violence is involved. You can, as a responsible member of that community, offer to mediate. Now, one ingredient of a mediator, one qualification of a mediator must be neutral and not take side. The moment you begin to take side, it's no longer mediation. and the other party can be aggrieved. If he becomes aggrieved, he can walk away from mediation, because mediation is not compulsory. The moment mediation fails, parties can move to court or any other option to resolve their own problem. And while approaching parties in mediation, you must also seek their willingness to submit to that mediation. You do it in their presence, and at all point helps them to come to a point of agreement by themselves. They should be made to see reasons why they should come to a point of not forcing them, not manipulating them, not imposing anything on them, but you must sincerely help them to see reasons why they should agree on a position. So at that point, you will agree with me that I kept saying that we must, at this point, if we take good advantage of this, then we can be mediators. We can also be part of the justice system, providing access to justice to people, So in churches, you can also be a mediator. You can help parties that disagree. Even in churches, people disagree. So when you are a responsible person and a person of integrity, and people respect you, you have to earn respect by your attitude and your approaches. You must not be a high-handed person if you must be a mediator. You must be somebody that, carries a personality that people can trust you, they can believe in you, they can feel safe with you. So to that extent, you can assume a position of an arbiter, and you can also offer solution. Something that would have escalated and become a very serious issue, you can resolve it. So you are now providing access to justice outside the traditional court system. The way you cannot help the parties amicably resolve their issue, it is safer for you to allow them to proceed to court or to resort to another option in solving their problems. You are not courts. Courts have the mandate to pronounce a judgment, and that judgment is binding whether the parties like it or not. A mediator does not possess such power, so you cannot impose your decision on them, on the parties where they are dissatisfied, or one of the parties is dissatisfied. He can move from there to court and seek redress over his grievances. Now, I will take all the mechanism before we allow room for questions and contributions. So that's number one, mediation. Number two is arbitration. Arbitration is a little bit different from mediation. In arbitration, the arbiter is given the power by law to make a decision on behalf of the disputing parties. Yes, they are allowed to sit in a mediation, and in arbitration, the people that are the disputing parties are also part of the decision. The process is similar to mediation. You bring in the parties that are disagreeing, and in arbitration, it is the parties that choose the arbitrators. In mediation, you can assume to yourself to be a mediator, and you can successfully do it to the end. Or you can be chosen, and you can assume yourself to the position too. But in arbitration, parties choose their arbitrators. There are like three in arbitration. You have like three arbitrators in a matter. This party bring his own arbitrator. Another party bring his own arbitrator. There is a number three arbitrator who is not connected to any of these parties. He's like a neutral party. So arbitration is closely related to a court system. The only difference is that here, the parties are also allowed to be part of their decision making, just like mediation. They speak. Arbitration happens mostly in corporate disputes. Contractors who don't want the hassles of litigation, who are careful about their business relationship with the people they are doing business with, they are careful that they resolve their matters in such a way that they can still do business tomorrow. Because naturally in the traditional court system, people are very grieved whenever a matter go against them. So many times they go home grieving, they go home with grudges, they go home with prolonged bitterness. Okay, sorry, I have to take a little break. So, but I'm back. So in arbitration, I was talking about the traditional court system, where at the end, no matter how fair a court decision is, the party that has lost his case is usually angry and is grieved. Yes, Stella, you have to off your mic so that you don't distract the class. So he goes home grieved and is so dissatisfied. You know, there's this feeling that comes with losing your case in court. Parties are just naturally not happy. So one of the ways that corporate organizations resort to arbitration most of the time, they are careful to preserve their business relationships with their partners so that even after, yes, disagreement is a normal thing, it's part of life. Husband and wife disagree, students and lecturers disagree, parents and children disagree. Even in the marketplace, a business person disagree with his customer. It's a normal way of life. It's part of life. Even if it's not normal, it's part of life. And it's something that is an unavoidable part of life. So in arbitration, the decision taken many times is taken by the arbitrators, but they help their parties to see reasons why such a decision will be taken. And where such decisions are taken, they are, if it is managed very well, they are satisfied with it. Nobody is imposing anything. One key feature of ADR is that parties are involved in their decision, and many times they are happier with the outcome. There's a level of satisfaction they go home with from the outcome. They are not grieved. They don't feel the decision is imposed on them. Now, in arbitration, the parties take decision on behalf of their clients, but they make sure that the interests of their clients are accommodated and the clients are carried along. The disputing parties are properly carried along. Sometime in an arbitration session, there has to be a breakup session where the arbitrators will step aside and speak with their parties separately and reconvene. The essence is to achieve an amicable resolution of in a dispute where parties can go home and still relate and still feel at home with each other. So that's the number two mechanism. We've done mediation, we are doing arbitration. Now, negotiation is where parties engage in direct discussion with each other. You know, negotiation can be done by just the parties themselves. Now, two people are arguing, and one of them develops courage and approach the other person. Can we negotiate? Can we talk? It could even be in a business transaction. Maybe. One of the parties develop courage and approach the other party to negotiate. Negotiation can be done between the two disputing parties and they can reach a conclusion. Yes, you are owing me money. I loaned you 100,000. Now, the time you were supposed to pay has elapsed and you are not paying. A dispute now arises. Now, the other party is saying, I've not gotten the money. I was expecting that I will get money from the proceeds of this one and this one. It couldn't come as expected. Now, the person that loaned the money is looking at the time and the resources he's going to spend in courts. If he wants to take this matter to court, it may take him the next 3 years maybe to conclude one court case. And by the time these 3 years have elapsed, and even if he gets judgment in his favor, and the court asks the person that is owing, this person may say, yes, I have agreed to pay, but I don't have all the money. The court will ask him, how many installments can you pay? The man now said, okay, I'll pay in 5 installments. I'll pay 20,000 naira each month. Now it's going, if that is agreed, because the court is also careful not to impose certain conditions on the judgment debtor, because if he insists he must pay in 1 month and he does not get the money in 1 month, what do you do? So the court will give a reasonable time. He may not permit him to pay in 10 months, or 5 months, but he may look at a reasonable period within which the judgment debtor can pay the debts. Now, if he now end up paying 20,000 in 5 installments, that's almost close to half a year again. How about the value of the money? The value of the money is long lost. Now, in a circumstance like this, okay, the party that is they are owing him may approach the other party. Okay, so what's the best option? Let me take off part of this money if you can pay, say, 80 or 70, so that we close up this case and go. So if the other party now sees it reasonable, this person is so magnanimous that he can write off 30,000, let me just go out of my way to raise this 70 and pay. That's negotiation. They have agreed, and sometimes it works perfectly for every party. And this person goes out of his way to raise the 70,000 naira and pays. Now, this person has gained because he knows that at least within the short time he's able to rescue the 70,000. It has more value. He doesn't have to pay a lawyer to go to court for him. He doesn't have to pay an appearance fee. He doesn't have to waste all the years of waiting for this money to be paid. Some can cut it down as much as 50% when it becomes a desperate case. They are able to rescue what they can rescue and put it in another business. So they see it as a win-win situation and they walk away. So negotiation can be done between the parties involved, but it has to take one of the parties to develop the courage to approach the other for a negotiation. And when negotiation fails, they can resort to arbitration, or they can go to mediation, because mediation involves a third party coming in to help them. Now, the number 4 mechanism is reconciliation. Reconciliation, is mostly done in parties that are at war, where it's not just mere disagreement, but much grievance is already involved, and parties have to be helped in a reconciliation. Even here, a third party is involved, and this third party has to be a neutral third party. Let's look at example of a matrimonial dispute. Reconciliation is used so much in matrimonial disputes, and this third party in matrimonial cases should likely not be a family member of either of the parties. Let's say husband and wife are quarreling seriously, disagreeing, not talking to each other. The natural tendency is that if it is the parents of the wife that comes in, there's already a mindset that is on ground
Hello.
Yes,
Hi.
Am I the only person not listening to getting high again?
She's not
no, you are
connected.
not. She's
Maybe
connected, but she's mute.
maybe the network. Okay, yeah, she's muted.
All right. Hello. Hello.
Yes, ma'am.
Yes,
I
I'm
am.
back. I'm trying to. I suddenly developed one unusual cough, and I don't want to be distracting the class. So when I go off from time to time, I'm trying to handle myself in a way. So I was on the issue of reconciliation. So you will now discover that the moment is one of the parties' relation that is coming in to reconcile these uh, disputing parties. There's already a bias in the mind of the other person. This person will be biased, you know. So one of the necessary ingredients in ADR is neutrality of the parties. Where a third party is involved, you must be neutral. So reconciliation takes place in situation like communities are fighting over land, you know, families are seriously in conflict, in disputes. You can offer your hand in reconciliation to help. And at such point, if you succeed, you will discover that you have saved, you have offered justice to these people. You have become an instrument of access to justice to such a family without having necessary to go and fight for divorce, go and fight for separation, begin to fight over children, custody, and all. Anyway, where the dispute is to a level that you as a reconciliator, you as a mediator, you as an arbitrator cannot handle, let the matter be referred to a traditional court system, because these ones have the power by law to take decisions that nobody has, you a mediator do not have. You know, though in arbitration, where trained arbitrators are involved, you know, arbitrators are actually trained. They are not like where you come in most is in the area of mediation and reconciliation, because arbitrators are trained and given certificate so that their decisions are filed in courts, where arbitrators reach a decision on behalf of their parties. It can be registered in courts and considered as consent judgments, which will be enforced by the law. So you cannot just become an arbitrator, but you can be a mediator, you can be a reconciliator. Now, what are the benefits of ADR mechanism? It's a complete justice system and you can be a key stakeholder. You can also help people who are worrying to seek these options. People who are complaining we don't have money. Why not reach out for arbitration? Now, if you come to our state like now, in the Ministry of Justice, there is a whole center called the Mediation Center. It is situated in the Ministry of Justice. It deals with issues of business, relationships that have gone sour, matrimonial issues where parties are worrying, where there are conflict over custody of children, where, several cases, even when people disagree in business, they can approach the mediation center. In the mediation center, you have chartered arbitrators who are lawyers employed by the ministry but trained. You have chartered mediators. You have people who are trained to handle these various aspects of ADR. It is free. You don't pay for it. So the mediation center is in existence. You can file your cases, approach them. They will tell you the procedure. Approach them. And if you see families that are fighting endlessly, you can also advise one of the parties to approach the mediation center. That's one angle. Another one is we have the gender unit in the police station, the police headquarters in Makurdi. They have a family unit where matrimonial issues, there can be intervention at that level. So these non-court avenues, you can even approach the Ministry of Women Affairs, where there are disputes in families, the parents are not catering for the family. Maybe the father is not providing for the children. You can approach the Ministry you can approach the Social Welfare Department under the Ministry of Women Affairs, who can also intervene. So what I'm saying is that justice must not only be gotten from a traditional court system. There are all these avenues everywhere that we can explore, which you can either refer somebody or you can also do something to intervene. And yesterday we also, on the day we're talking about human rights, we also mentioned other organizations like NAPTIP. You can also refer somebody there to get justice. Where you don't have the power, you can refer, so that we don't just, relegate the issue of justice only to the traditional court system. All these avenues are here as interventions that can help. So what are the benefits of ADR? It brings about a faster resolution of cases. A whole conflict that has been going on can be resolved in one day or in one meeting. Parties can just be helped to realize, oh, wow, what have we been doing all this while? Oh, I agree, like this, I agree. Or 2-3 cities can resolve a whole conflict instead of prolonged process in courts. So it's faster, it's cost effective. Sometimes you don't even spend money at all. Imagine that you now, having learned that as a responsible member of the society, you can intervene and mediate. And you see people whose situation is degenerating, you intervene. You may not even ask them for money. You can just help them to resolve their issues, and that's your contribution to the society as a member, responsible member of the society. So it could be cost effective, but even where professionals are involved, it's not as expensive as when you are going and paying for different things. It increases control. It preserves the interest of the parties. The parties are involved. Their interests are preserved. Nobody is deciding anything for them. They are, then it creates a sense of involvement and satisfaction in the heart of disputing parties. It also preserves relationship. I mentioned that in passing. It mentioned that in passing. So they can take full advantage of ADR. People can disagree and still do business if it is well handled and it's handled in a manner that they are emotionally and psychologically satisfied. They can have confidence to still relate and work with such a person at another time. So let me pause at this point and ask for questions or contribution before we go to the last lap of the issue of access to justice, which we now propose a way forward. Any question, any contribution, anything you have to say? Now you can indicate if you have a question or something to say. Is there anybody's hand that is up? Anybody who want to say something?
Yes, ma'am.
Okay,
My
Jeffrey,
hand
go
has-
ahead.
Good morning, ma'am.
Good morning.
Thank you for articulate handling this class. The confliction I have is, what is the difference between mediation and reconciliation? A reconciliator and a mediator, they are
Yes.
striking rules.
Okay. And the substance of the dispute is what differentiates the two. Like when I was talking about it, I say reconciliation takes place mostly where there is, there's a kind of, can I say, war or fight. Tempers have risen so much. And you are, first of all, trying to help these people to come to a point of peace. Like I gave example of like warring communities who are fighting over land, let's say landed dispute, where you see where sometimes they fight and burn houses, kill people. It's a warring situation. Now, a mediation could just be in a simple dispute where people are just disagreeing, but it has not gotten to that level. The role of a reconciliator and a mediator is not different. You can assume, you can be appointed. Your own role as a mediator and a reconciliator is not different, but the substance of the dispute is what distinguishes them. So a mere quarrel, a mere disagreement, but in reconciliation, the parties, the intention is to have the parties, first of all, reconcile with each other. That's what the name implies, to reconcile, first of all. Now, families are separated on account of disputes. They are no longer talking to each other. The spouse, the husband and wife, they are not in talking terms. They even want to walk away from each other. You have to reconcile them to help them realize they need to live with each other first. Where that happens, before you can even go into the substance of the matter. But, in a situation of mediation, it may not necessarily be to that extent. You can just help them deal with the substance of the matter. Emotions are not so attached, feelings are not so involved. But if you have witnessed a landed dispute before, you know there is war. So when you don't, first of all, help these people and you begin to go and jump into it and decide who is the owner of the land and who is not, if you don't take time, your life can go for it. So you have to, first of all, help them to come to a point of peace. Lay down their arms first. That's the point of a reconciliator. Help them to see they need to live as brothers first. And then you can now dive into the substance of the matter. So I don't know if I've answered that before we take another.
All
right, so Grace, I can see your hand up.
Okay, thank you so much, Ma, for the opportunity. Okay, I want to just share a bit of my thoughts in regard to reconciliation, Ma.
Yes.
Okay, so I, from my understanding, in the reconciliation, once someone has intervened, and like you said, the person doesn't have to take side. So
Yes.
is to ensure that when the issue has been dealt with, so that the people can still be in talking terms. Like you said something about when you get to court and somebody loses, the person might not, that relationship will not be maintained again. But in reconciliation, like they keep their differences and at the end of the day, they can still relate, they can still live in peace, like together. They can still be in talking terms because it's to ensure that these people keep their differences and now they can forge ahead together. So that's my own understanding, ma.
Yes. All right.
Thank you.
Yes, you are right. And that's the beauty of a reconciliation and the ADR. It helps people to realize that they didn't just impose this, because I've seen, like, in matrimonial cases in court in particular, even for us that are in the legal profession, sometimes you are not just happy the way when marriages are separated in court, then the next issue is a custody of children. You see a woman is crying because they allow the husband to go take charge of the children. They're either fighting physically, pulling the children this way, pulling them this way, bringing a lot of psychological burden on the children. And you also discover that even if the court succeed in giving, of course, the court will always look at parameters, measuring parameters before they reach a decision to give the children over to one of the parties. They do that, but the bitterness will prolong almost for life. It affects the children, it affects the families, it affects the extended family, it affects everybody. But imagine that you are able to succeed in helping both the husband and wife to see the need, why they need to shift ground, at least maybe for the welfare of these children, and they see it and they're able to let go their grievances. You have saved a generation from the collapse that would have occurred if if that intervention did not come. So we can explore this. Yes, you can train as an arbitrator, you can train as a mediator. There are organizations that train people for this, for them to get professional skills so that you are well equipped for such. So it's very useful. It's a very useful tool. Sometimes even in workplaces, somebody can just start disagreeing. If care is not taken, people can fight. At the end, the two of them, if they are civil servants, they end up both losing their jobs on account of fighting at work. But this thing can be intercepted if you have the requisite skills and you are able to intervene and help the parties to come to an amicable end of their dispute. It must save them. It has saved generation. It has saved them. They can relate again. They can still maintain their jobs instead of ending up in a fight and all. So I don't know, Jeffrey, is your hand still up? Or is it the other time you have not brought down your hand?
Yes, ma. Yes, ma. My hand is still up. I wanted.
Oh, all right.
I haven't received that explanation or clarification. There was
Yes.
a question I wanted to ask further. This, I understand you in clear terms that uh, uh, mediators, first of almost, those persons could be, they are more voluntary
Yes.
than this, the role of arbitrator, who is a trained person and deals with complex cases of trades, and
Yes.
maybe companies that are careful about going to legal matters that will get them involved. When this, my question is this: when this issue is handled by the arbitrators,
Yes.
and though as it is more civil, it's more, it's free of a traditional legal, traditional court system. Uh, is it advisable the is it advisable they append and they have an agreement sealed as a result of tomorrow somebody may want to break off from the initial reconciliation and seek legal redress, though it may not, their handling may not impair anybody who further wants to go to court. But would there be any reason for them to have a written agreement to show that a, a reconciliation or an arbitration held and resolution was made and both parties agreed to it?
Yes, why not? In fact, in arbitration, there must certainly be an agreement. There must be an arbitration agreement, which is enforceable by law. In arbitration in particular, where parties agree, they reach an agreement, they sign, and it's registered in court. So it can be enforced. Even in mediation, where it is a bit formal, and it's not just that we have helped to reconcile the two of you, you can go. If it's in simple cases that require obligations, where the parties have obligation to fulfill, you can write a mediation agreement and sign. But like I said, in mediation cases, sometimes where the other party now fails, the matter can go to court. And also remember that sometimes cases that even start in courts, where parties want to try any of these mechanisms and they apply, the court can give them opportunity to go and try to handle it out of court. So in that situation, the court supervises the process. They report back the progress. That's where the matter went to court. Okay, in essence, what I'm saying is that even where the matter goes to court and the parties have a change of mind, they can withdraw their cases to come and settle them out of court. So where an out of court settlement is taking place, either of these mechanisms are the ones that are employed. It's either they are using mediation or negotiation, but when they are all done, they now go and file their terms of settlement, and they have to keep to it. When they don't keep to it, the matter can go on in court again. So there is no harm in written this thing. In arbitration, it's even a compulsory requirement that there must be an arbitration agreement, where parties are bound. So it's not even an option, because arbitration deals with more complex cases, and all the efforts cannot just be reduced to a verbal arrangements. Any other person with a question or clarification or contribution before we go to the last lap of this topic? Okay, so.
Hello, ma.
Yes, Joseph, good morning.
Sorry, just good morning. Just a little contribution. I see in the case of mediation, especially in the family, where maybe there is a dispute and fighting. It's not only in the family where fighting occur. The mediator mostly being affected, maybe at the cause of fighting, people go there to separate fights, to even find out what is happening. At the end of the day, you discover that the person who went there to mediate may be injured from there. And those things maybe scared people away from such things, that if there is a fighting, if people are, two people are fighting in a family or outside, you see that they are scared of even going closer. So by watching them, people nowadays, they watch them to see how the fight is going. And at the end of the day, one person may be injured seriously, or it can lead to death, because in the case of fighting, people carry sticks, carry objects, and try to harm one another.
Okay. Yes, I agree with you to a level. Now, mostly this area is applicable in civil cases, where where violence is involved and matters involved are criminal in nature. It's advisable to involve the security law enforcement agents, because they are empowered by law to use even the use arms where they can no longer handle the matter, where it is just beyond mere intervention. But you and me, we are not empowered by the law to do that. So where a fight is beyond, it becomes violence, it is advisable, because these people have lost control. They can harm you in the circumstance. So it is better to quickly call on interventions order. So there's an extent of involvement in you're trying to intervene, ways beyond you. Do not insist on doing that. Okay, for the sake of time, let's go on.
I'm sorry, ma'am. Just one last question. We made mention of trained arbitrators. So, what is the pre-qualification and duration of their study, duration of their training?
Yeah, they differ. They differ. There's a Institute of Chartered Arbitrators. There's Institute of Chartered Mediators, based in Abuja, Lagos, and other jurisdictions. So I think once you Google them, you see the basic requirement, but you mustn't be a lawyer. Let me just disabuse your mind on that one, so that you don't think that it's only lawyers that are trained. No. In fact, it's students, social workers like you, development workers, people that are in touch with the society, very useful people that can be trained in such capacities. So, but I think when you browse it, you get the details much more. But those some are even online now. We don't have any in Makurdi here. They mostly Lagos, Abuja, the Port Harcourt, the last I knew. So, but sometimes the trends are changing, just like we are doing online lectures now. Some of them may have gone completely online, where it would be easy for you to do. So you can just browse them. Chartered Mediators, Institute of Chartered Mediators, Institute of Chartered Arbitrators, and stuff. So you get details from that. You can do it too.
It's okay. Thank you, ma.
So we are looking at the way forward, talking about access to justice. We look at the impediments. So we are going to quickly look at the way forward. What are our suggestions? How can access to justice be improved in our jurisdiction in particular? Because we can see that everyone needs justice. You need justice, I need it. I may not go and look for somebody's trouble, but somebody may look for my trouble, and I will need to seek redress. So we've looked at the traditional court system, we have looked at ADR, and then we've seen their shortcomings and all. So how can these things be improved upon? Because it is a necessary, ingredient of our survival as members of the society. So we first of all talk about the funding for legal aids, because they have to be properly funded. Because, where agencies that are offering free legal services are not well-handed, they become avenue for corruption. Where the people now complain, okay, we don't have transport to go to court today. You have to give us, even though you are not paying, you have to give transport today. Okay, this witness is from Okun. We have to go and get him, so you have to pay so amount. Yes, you are not paying, but this one here, this one. So when there's increased funding, and the authorities that be also are appropriating the funds very well, it can help improve on access to justice. So that true to it, where you are not made to pay for services you truly don't pay, they don't get it through the back door or through another means, then the pro bono work should be encouraged, especially maybe among lawyers. For you to attain a certain level of your law career, you must also have evidence of how many cases you have helped people to do free, because that's community service. You must do community service with your career and profession. So pro bono work, meaning where you do services free for people, it should be encouraged. Now, the funding of our court system should also be encouraged. That the judiciary autonomy that the judiciary have cried about severally. Their budget should be given to them, and they administer it the way they should. But that administration should also be, as much as possible, be devoid of corruption, where monies that are approved for certain things should be used in such a manner. We have discussed ADR. ADR should be encouraged to resolve cases. In fact, there has been a proposal that some cases that are in court, even the court itself, should refer certain cases to ADR to reduce the workload on the courts. Where you notice that there are some cases that are minimal, you can refer them to mediation center, talk to parties, and make them see the need to approach the ADR, explore the ADR mechanisms to resolve their cases. So it should be encouraged, both even from the court system. The lawyers themselves should be truthful enough to help intervene without looking at the monetary incentives that they may lose if they don't necessarily go to court. ADR practitioners should be trained. Like I suggested, you can be trained. When you are trained, you acquire better skills. You are ahead, because in some instances, if you are not trained, the disputing parties can even get you to become angry at trying to mediate. You become offended, and then you take position, you take sides, and the whole thing becomes sour. And then you now discover that you dove into the arena of justice yourself. You have become part of it. So you need a training, basic training, so that you can acquire the basic skills. Now, there's also a proposal for community-based initiative that can even be handled by the traditional institution, a more formalized arrangement where some cases can be handled. Then online dispute resolution, digital access to justice. I remember during the COVID year, some courts began to sit online and even deliver online judgments, where it was no longer the convention for people to congregate in one place. People had to do online sitting. They, from different places, they could hear the courts, we hear them online. But again, when we talk about online sitting, we also have to assess our preparedness in terms of technology, where we are always, even in lectures, we are being thrown out, I cannot hear you, I cannot, but you also appreciate the fact that we are making some progress even here. So if we had just relaxed and say, oh, it's not possible to do online lectures, so let's just forget about it and continue with our face-to-face lectures, we wouldn't even be here. So considerably, we have made some progress. So the issue of online hearing can also help. This will also solve the problem of people saying, I don't have money to transport myself to court today, or I cannot bring the witness because he stays in another state, and how it will take me so much to be able to bring him over. So it will solve some of those problems. And then some logistics issues can also be handled where hearing is online, judgment is delivered online. Then finally, awareness, legal education. Legal education becomes one of the issues that we must be deliberate about. As somebody that is a society member, you can collaborate with maybe a group of lawyers. You can bring up an initiative, collaborate with one or two lawyers in your locality, and create legal awareness for your community. Teach them about basic rights. You can do that for your church. It must not be initiated by a lawyer. Having been aware now that, yes, you can also contribute in terms of awareness in your community, it's important that you can go and start something. Call one or two members of your church, that is, they are lawyers. Okay, we can educate our church. We can go back to our village. You are now a lawyer in town. We're in primary school. We lived in the village together. Now you have become a lawyer. Let's go back. Do town hall meetings. Call our youth together. Enlighten them on some of these issues. It may save their lives, because what they do today and go away with, tomorrow they may not get away with it, and it will lead to loss of life or something. So you can educate them and also help them to know that, yes, they have the right they have certain rights, and those rights are inherent, those rights are non-negotiable, those rights, they are entitled to it. So they can make use of it, they can explore it, they can take advantage of their rights, and they can seek redress when those rights are violated. So basically, this and much more. If there are other proposals, you can submit. You can also voice out. We are looking for way forward. How do we improve on our justice system in Nigeria, be it the traditional court system or the alternative dispute resolution or other means? How do we improve on it? Because we are going to be rounding up at this point. So make your points before I make some announcements and we close for the day. If you have suggestion, we must suggest way forward. Okay. So I think we have touched on some of these things repeatedly. So we will stop at this point. Let me go back to our presentation announcements. We are going to do our presentations tomorrow and Thursday only. Friday, I will also take a wrap-up lecture where we will make clarifications on issues that maybe, we didn't touch in the course of our lectures. But we took turns. I assigned presentations for tomorrow and Thursday, and the agreement was each presentation is only going to take 10 minutes, leaving us with the remaining time to discuss, make inputs, make contributions, and all. So
minutes so good.
okay, so like I attributed, we share topics. Grace is going to take topic 1 and 2, and topic 3 is going to be taken by Joseph. Topic 4 and 5 is going to be taken by Precious. Topic 6 is by who again? Joseph, can you recall?
By Dende.
Okay,
by
by
Dende.
then. Okay, all right, yes. So these are the people presenting tomorrow. I saw then they just came up much later. Somebody should help me inform him privately so that. So our lecture tomorrow again is 9. So the remaining topics will be taken on Thursday. If you fall on the remaining topics, your turn is on Thursday. We are going to do our lectures tomorrow 9 again. So all of you presenting tomorrow, like I said, is like a snapshot of what these topics are, because each of these topics can be a whole course of its own. So you give us a snapshot of what the topic is about, and by the time you are done presenting, okay, so by the time you are done presenting, we make our contributions and inputs and all. So I think that's that for now. So some of you that I didn't call your name, you know your name, you know yourselves. So prepare yourself against Thursday. So I think that's all for now. May call it a day at this point.
Thank you so much, ma.
All right,
Thank you,
so
ma'am.
have a good day.
Thank you, ma'am.
All right, thank you.